Good evening, YouTube. This morning, whilst I was on my morning walk, I was telling a local neighbour walking a dog also of my legal case that I've started against Her Majesty's government. I forgot to redact this, redact my address. Hopefully that wasn't caught. We get that in there. Okie dokie. This is a copy of the sealed application form in which I apply for judicial review, a British process. I don't know whether the US has it, but it's a long-standing British process wherein the public functions can be challenged. The case is filed urgent with an N463 application. And I was telling my neighbour that I'd filed this to get Julian Assange released with an interim order. That's before the actual judicial process begins, with using a writ of habeas corpus, which it was my former video. This is one of the confirmation documents that I've had to serve upon the parties to the case, who are Julian Assange himself and the government, telling the parties they are now party of a case that has been lodged. I've been working for some 12 months in scrutinizing the submission of Julian Assange to the United Nations Working Group on Arbitrary Detention. It's a long, heavily referenced document, and I'd come up with the following structural diagram of that submission. What you may have seen is from the 5 presented pillars there, a development into around 10 pillars, but the structure diagram is yet to be updated, because I'm working heavily on what is currently over £1,000-page submission myself, which has to be ready very shortly, given that it's an urgent submission. The basis of the submission is the Julian Assange submission to the working group and the decision of that working group. It is also cited as a basis that there's been similar findings in the Inter-America Court of Human Rights. It is reported. I've not been able to get a translation of that decision. So when I meet my neighbor, she says, "Oh, he chose to be in there." And I said, "Whoa, let me tell you about the choosing." I said, that will not legally stand. In the former video about judicial review, it's interesting to note that John Lill, slips my mind, he was imprisoned on an island away from England, and he was offered the choice: we will release you so long as you promise not to continue publishing dissenting material. And he refused, and he paid a high price with it. Now, that lesson to be learned has been learned several times in the case law that is cited in the Julian Assange submission. And I explained to my neighbour how the UK in Abdi versus UK held an asylum seeker in what seemed like indefinite detention, and they posed to him, we will let you free, we will release you so long as you sign your rights away. And it was held that the notion of a Hobson's choice, of asking a person to choose between the two fundamental rights, the right of freedom versus the fundamental right to petition for asylum, is not a legal move. The UK recognizes without doubt, yeah, I've downloaded documents and can show you that the UK recognizes the concept, the idea, the legal precept of asylum, that is protecting people from persecution, death, and unfair treatment. This is a fact. You can't. I'm going. So there are at least 3 other cases cited in the Julian Assange submission: Stark versus Germany, Amour versus France, and Guzzardi versus Italy, which deal with similar concepts, or also Al-Jabouri versus Lebanon, and perhaps others. All thoroughly read and annotated and highlighted in PDF form, and brought together in a schedule for easy navigation and recall. More than that, the schedule of some other earlier fundamental instrumental important judgments that relate to the nature of human rights and the protection from arbitrariness and discrimination. The case of Golder versus UK that demands that we take a purposive look at legislation, at human rights, that says the preamble points to the purpose. And so the preamble is very much a part of, an important part of the human rights documentation. Other law enhances and broadens the notion of arbitrariness about acting to the notion of defeating a person's autonomy, that a person is autonomous from state. This first arises, I have it in Marx versus Belgium in 1979. In Uri versus Ireland, we talk about the practical effects must be thought of, and rights must have a concrete nature. They mustn't be theoretical or illusory or abstract in any way. We have stressed the need for clarity in law, availability in law, and the need to regulate unfettered power. And that is where it is deemed a discretion needs to be given to a person, that discretion has to be confined within some bounds. There can be no unfettered law or discretions. So I corrected my neighbor about the notion of choosing between two fundamental rights, and I'm surprised that the airplay that this gets in the public. Furthermore, just a note on arbitrariness, because the UK is now involved in, let's say, a more procedural element of the detention of Julian Assange, it would be wrong-headed to think that they are now escaped the condemnation of arbitrary detention. You see, if this much punishment, is necessary to achieve a result, yeah, but you impose this much extra punishment, then you have gone beyond that which was needed. If you go beyond that which is needed, then you have acted disproportionately and arbitrarily so, because the amount that you've gone beyond could be is a particular choice. There is no formulation to decide between whether you go 2 units beyond the required amount to deal with the problem or 10 amounts. So whenever a government acts disproportionately, it is by extension acting arbitrarily. Julian Assange has been in captivity for 7 years. The continued captivity based upon an arrest warrant, or should I say, in the UK's case, actually skipping bail to seek asylum, has become, in my judgment, in the judgment of the working group, excessive. They do not, and when the asylum card is played, because the UK subscribes to this, it is wrong of them, arbitrarily wrong of them, for them to dismiss the legal notions of that claim, such as, well, he's just trying to, with the words just, he's just trying to evade Swedish justice, or he has chosen. These are superficial notions which are not dealing with the complexity of the case, and the UK government doesn't get to act so superficially. That is arbitrary and leads to disproportionate treatment. And that concludes. I've said more than I wished. I just wish to explain and disabuse a few notions that are put out there in the public, and in the legal realms and in the political realms, about the silly idea that someone can dismiss the fact that he appeared to voluntarily walk in to seek asylum and take refuge, that somehow he has forfeited the rights that are in play in the argument. Far from it. And now a legal process has begun. The UK government will have to answer to these complexities. The strands that I deal with extracted from the Assange report read as follows. There is the firm basis that there has been an opinion expressed, a judgment expressed by two world authorities that Julian Assange is arbitrarily detained. There is a fact of an arrest warrant which was issued, and the subsequent issues that Julian Assange case has raised has led to the UK law being changed such that if the extradition warrant had been requested, the European extradition warrant had been requested at this time after the law change, it would never have been granted. Unfortunately, Julian Assange isn't able to get the benefit of that change. That too is wrong-headed. Now, it is understood as a fair principle that you don't backdate punishments when you change the law. But when the law changes because the character of the law is wrong because of an unduly unfair or arbitrary aspect, then it is natural to understand that everybody who was affected by that law has a case that they were treated arbitrarily, and a good case for that law should retrospectively apply, especially in Julian's case, I think. Great. There is the Swedish issue itself, which raises the very fundamental question: have the US, Sweden, the UK, and probably other European countries shot themselves in the foot, insofar as when every time his story makes news, the first breaths out of the mouths are about the Swedish case. And it's not a case of unconsensual sexual intercourse, apparently. My understanding is it's something to do with concern over a broken condom, two women realizing Julian is promiscuous and getting concerned over the possibility, the fact that they discovered each other and that they both slept with him, about sexually transmitted diseases. And they wish to force, through law, Julian Assange to have an STD test. The first prosecutor who looked at the case dismissed it and said there's no case to be answered. It seems that there's a politician got involved and flew these two women across the country to another prosecutor who then revived the case. All very arbitrary, it seems. The other strands relate to the fundamental respect for asylum and the risk of what is called refoulement. The basic thought here is the UK is bound by asylum law. We bind ourselves to asylum law, international authorities on it. Those same authorities explain that if a country does not also think about the concept of refoulement, that is, that if they deny a person safe refuge, and because the country they're going to does not, that particular country does not present the direct threat, but there is a very real threat that the person can be moved more easy or from that country to the threat, then the principle of refoulement says that that person can't go to that risky country. And the idea is, by the authorities, is that without this protection from refoulement, there really is a fundamental undermining of the concept of asylum in itself. It's a universal concept, or supposed to be, adopted by many countries. To allow yourself the arbitrary blinkers to say, but we sent him to a country that that wasn't posing that particular threat, is to undermine the concept, and those blinkers are not really and shouldn't really be permitted, and to use them is to be in breach of international law and respect of the asylum itself, the whole edifice and principle of asylum and protection of asylum seekers. And so I don't know whether I don't think I finished the point about the fact that this Swedish case of a sexual nature with the R word has been branded for 7 years. The fact that the American government has withdrawn from the UN Human Rights Council, the fact that the US government has, well, sorry, first of all, there's no chance of a fair trial, right? Because of this, yeah. Leading politicians, leading figureheads, all inciting, yeah, and repetitively the news outlets reverberating these charges, meaning he has no chance of a fair trial. Separately, there is no legal way he can leave the UK to the US. It's quite simply, it seems to me, a ridiculous notion for any charge. They are very clever, the US, to not pose a political charge, but a computer charge. They've titled it hacking, but there's no hacking involved. Yeah, that is purposeful as well and prejudicial, such that all the news outlets, the banner title is Computers Assange hacking charge. But there's no way he can go to the US because they've withdrawn from the UN Human Rights Council. They've torn up the not only the Iranian, the Russian nuclear treaties, so they have no respect of international treaties. If he was to leave here to there could be no understanding or reason to believe any promise of not laying further charges with heavier penalties. The US tortures prisoners. The US executes prisoners. The US, if you visit the Iraq Inquiry website, also known as the Chilcot report, there's 42 legal submissions, and I've read about 20 of them. All the superficial 2-page ones, yeah, well, all, there's not so many, but some claim the Iraq war was legal. They're 2-page superficial efforts, yeah. The ones dealing with the complexities all come to the opinion that the Iraq war is illegal. And it's quite astonishing to read those and find out what the legal justification was. No man in the street knows the legal justification in the UK. It is a contrived, unbelievable piece of fiction to connect one UN resolution 10 years after the Kuwait permission to push aside Saddam Hussein out of Kuwait. Yeah, that the permission of authority 10 years earlier, they've contrived some mechanism to say that it authorized action at this under this later juncture. Yeah, even though the UN resolution, the later one, says we remain seized of the case. Yeah, and everybody understands that you cannot go to war without the permission of the UN, and the permission of the UN is going to be very hard to find. It's only available in extreme self-defense or in extreme humanitarian need. So the US goes to illegal wars. Well, and unfortunately the UK too. But so I can't see any possibility there. But yeah, as you've seen in my prior video, telling you about this mechanism of habeas corpus, however it's pronounced, it may well be an effective remedy to have him released within a fortnight, maybe a week even, depending on the replies. I'm expecting to have an oral hearing in regards of this case. We have a bank holiday Easter weekend now, so it may well be push Tuesday, Wednesday before. I'm going to go now. Neighbour coming. See you later.